It is Wednesday, March 6, 2019, 5 o'clock p.m. Central Standard Time, and welcome to week five of business law. And as I said 5 weeks ago, quarter goes very fast. The quarter will end in 9 days from today, which will be the 15th. So hopefully that you guys will have turned in your assignments. I am accepting assignments only from weeks 4, 5, and 6, unless I made previous arrangements with you based on extenuating circumstances. But those who I have had extenuating circumstances with have submitted 1, 2, and 3. Remember that it is important that you get weeks 4, 5, and 6 in on time, and that you complete the assignments on a timely basis. So let's go right into discussing where we are here, sharing my screen with you. Again, I've indicated the importance of rubrics. I constantly refer to the rubric. I refer to the APA. I have told you about tools that we provide to help you with APA as well. All right. I also referred to the statute of frauds at the beginning, which many of you should recognize that when you're doing assignments, that what should trigger is one of those letters as to whether or not that contract needs to be in writing to be enforceable. And then, as you've been dealing with void and voidable contracts, but you should have printed up both of these. I emailed them to you. If not, they're located here. You just have to copy and paste to your browser and then download them, okay? And then about critical thinking video, if you have questions about critical thinking, you can look at this video. And so now let's go down and look at our rubric for this week, eminent domain. And I'm going to talk about eminent domain today, and your 10 points for summarizing eminent domain from research. Remember, it's from research. Don't just use your textbook. Some of you have just used your textbook. Make sure you use reliable and credible sources, not Wikipedia. Discuss whether or not the taking is fair. You get 5 points about that. Argue whether or not the government should be able to take the property, 10 points. And it's 2 to 3 pages, not counting the cover page or the reference page. It's very important that you get the page length right, because you can lose points for that. APA formatting, in-text and full citation, spelling, and grammar. You can lose 5 points for that. Okay, so moving right down to the course project. It is time for you to submit your final contract that you first did in week 2. I think it was week 3, where you submitted your rough draft. And I made comments to you and telling you what you needed to do to make sure that you satisfy the requirements, so make sure you review those. Include all the requirements, such as date, signature line, parties, location, etc., with minor errors. The clauses that need to be in the contract, I shared that with you during week 3, and the prices and quantities accurate as described in the fact pattern. Remember, you've had the same fact pattern, and include correct spelling, grammar, and APA. All right, so that's your course project. So you got 2 assignments that are due this week. Then finally, a reminder of your lecture that's taking place right now, 5 to 6 p.m. Central Standard Time, and that you need to attend or provide me with the key word that I will give you. Here are recordings from weeks 1, 2, 3, and 4 and then you'll see week 5 here. Then I'll also email you the link as well. Okay, so let's get to the weekly announcement. Here it is. Week 5, property, real, personal, and intellectual will be discussed. Chapter 11 of the textbook, Essentials of Business Law. Complete the activities, property of all shapes, sizes, and ideas, which I'll talk about. Common ownership interest for real property. And then you need to go over the flashcards, but I'll show you how they work again as I do every week. And then this gives you the information about where the lecture is located. There's the link there, as it is down on the other page regarding live lectures. Your discussion posts, initial posts were due last night, the 5th of March, 11:59 p.m. Central Standard Time, involved with the topic, why buy it when I can get it for free, and provide detailed information relating to the issues that are described in the actual assignment under the discussion requirements. Your reply post is due Saturday, 11:59 p.m. Central Standard Time. And finally, complete the eminent domain written assignment and course project, final contract. Pay close attention to rubrics, as I always remind you. And then you know what my motto is about, because I covered that during week number 1. Okay, let's get to the course tools. See the course calendar real quick, and you'll see how eminent we are. Notice where we are. Right here. This is today, the 6th. Live lecture. Reply post the 9th. Initial post was due yesterday, the 5th. Reading assignment earlier that week. Your written assignment is due the 10th, as is your course project. Both of those are due the 10th. Then you'll see we start Monday, the 11th, with just 5 days of class. Class ends actually on the 15th. Be aware of that. I should put that in there. Matter of fact, okay. Okay. Okay, so now it's there. There's your reminder for the 15th, for next week. All right, so you should already have known that anyway, because that's the last thing on the calendar, and then it is also in next week's announcement. When you get to week 6 announcement, you'll see that as well. So that's it for that. So now let's close up the course tools. Of course, you know your calendar is located up at the top, right up under, right there. And you can click on there, and then you can see your calendar as well. All right, so if you were to click on that, and you will see your calendar, because let's see, I got it. Let's get rid of that. Business 234, there we go. And you can see your course calendar, all right? So let's go straight to our module for the week. Again, going over the assignments in specific, reminding you it is a 2 to 3 page paper, located an example of eminent domain. That's what you're going to do for research. and then provide answers to these 3 bullet points using citations and references and sources, 2 to 3 pages. Okay. The discussion posts deal with this issue here and explain these answers to these questions. And then your final course project, Mr. Barker, who you met in week 2, and you're going to set out the agreement that in the final stages, for the last part, you need to submit the final draft of your contract. Look at my feedback that I provided to you in week 3. Be sure to check all the elements and proofread your final document for grammar and mechanics. And don't just use language because such and such a thing. Give me some legal language. Give me some things to support it. I had suggested that you can take a look at some sample contracts, not to copy their language specifically, but to understand what you need to do. You can take some of their language, it's okay, but just give credit at the end as a reference. Let me know where you got it. And then you want to be certain that you covered all the requirements to collect your money, to be able to collect your money. So we'll get an A, as you say. So in other words, satisfy the rubric. That's what it's really saying. And then your live lecture keyword is due Sunday. All 3 of these are due Sunday the 10th. So now let's get into the lesson content. The difference between lost and abandoned property, multiple ownership of property, intellectual property, and we're going to deal with that. So we're going to deal with the issue of property of all shapes and sizes, and then I'm going to talk a little bit about ownership interests and things of that nature. So let's talk about property. So what is property? Anything that you own, that's property. And they can be broken into 3 categories: real, personal, real, and intellectual. So what's personal property? Personal property is basically money, or either it could be ownership in land or rights to money, a pen, you know, this computer that I'm on, you know, this little ball. These are all property. Property is something that you own, all right, and it is tangible. When we start talking about personal property, in other words, you can touch it, see it, feel it. You know, this is my stapler. It's my property. Okay, so that's a very simple form of property. And so we deal with real, personal, and intellectual. So now, so with personal property, there you can have what we call a third-party beneficiary. But the contract or the deal is to benefit a third party. And it gives an example. After the wedding, Laura's parents offered to buy her and her husband a new home. Now, Laura's parents put in a bid on Laura's choosing, and the sellers accepted it. If for some reason the contract fails, then Laura has the ability to sue because she is an intended beneficiary, even though it was a gift. So she's a third-party beneficiary. What if the third party is incidental? For example, you're offered a job with your raise and you accept. As a result of the raise, then John is planning to install a new pool in his family's home. But the boss can no longer give him the raise. John's daughter is upset by the fact that they can't get the pool and wants to sue her dad's boss. John's daughter is an incidental third party and does not have the right to sue the boss directly. So that's because just because she was going to get the benefit of it, she doesn't have the standing or the right to sue in personal property. So these are little things that you won't run across a lot in this course, but it's just to indicate quite clearly that things are done for third parties, but if it's not directly, then the party doesn't have what we call standing to sue. So now let's talk about real property. Now, as you already know, I gave you the statute of frauds, which has my legs. M for marriage, Y for contracts a year over, L is for land contracts. So what are land contracts? Leases, mortgages, and things of that nature. So in order to transfer property, it is enforceable if it satisfies the L. And that's the legal reason why it needs to be in writing to be enforceable. Now, you can get properties from purchase. That's when you have a contract, you have a sales contract. Inheritance, where again, there's a will or a document that indicates that, or by adverse possession. So now let's talk about the purchase of real property. So purchasing a contract is a typical way, you know, and as I said here, under the statute of frauds, it is a contract that needs to be entered in writing because it's the letter L. Purchasing property is the most common way. What people do is they buy property all the time, sell property all the time. It includes a realtor, a broker, or it may be just you directly with the owners, but most of the time it's a realtor involved. And negotiate, the agent or realtor negotiates on behalf of their clients, the buyer and the seller, and then documentation is signed, money is exchanged, that's the consideration. Title will pass from the seller to the owner, and then evidence of that is recorded in the form of a deed with the county in which the property is acquired. That's simple purchase of real property. So all you have to do, remember here, is that land contracts need to be in writing. Inheritance is another way. So let's say it's left in a will, which, by the way, wills now in the law can be written as well as they can be video now. But the point of the matter is that let's focus on a written document, and it indicates how, you know, you're each familiar with the will. Property is left for individuals, and the individuals are responsible if they're going to accept the property for whatever goes with the property, such as taxes or any mortgages associated with the property. And they go with that, or any other liens that are on the property, okay? So it is not a requirement to do a will, but if there is not one, the person dies what we call intestate, which means that that's why you'll see the word executor. When you see the word executor, that means there's a will involved. When you see the word administrator, administrates, then that means that there is no will. But the state in every jurisdiction has a basis for how to put this property in probate, and the property is distributed based on what the law says in that jurisdiction, okay? And so it describes here very simply that heirs receive an interest in the property, and if there are none, then what we call escheats. When we were in law school, we remember first introduced that term. It means it just goes to the state, and the state becomes the owner of the property if there's nobody left, all right? So, real property, all right? Adverse possession. Now, we used to have an acronym that I used for the bar exam that I made up, but then many people started getting it. Now, adverse possession is not a common way. Pretty much it means that the person gets possession without paying that person an amount, or what we call squatters' rights, where they allow you. But the doctrine of adverse possession lets the person use the land and not allow it to sit vacant. And so the following elements must be met. Now, we usually use the word cone. The property must cone. The adverse possessor must cone. Must be, as you'll see here, continuous, open, notorious, and exclusive. So if you remember cone, continuous, open, notorious, and exclusive. That's the essential foundation. But as we go down these bullet points, you'll see what I'm talking about. The possessor must be in actual possession. Remember I said, must be continuous, open, notorious, exclusive, in possession of the property. So you must be on the property. Not that you can't leave, but you can't, as they say, abandon it. Must be open and notorious. In other words, others can see it. That's where we get to the open and notorious. Hostile. Now, this goes against the owner's interest, but hostile, if you do continue, open, notorious, hostile fits within that, but some separate it. But I hold my students to understanding cone. Continuous, open, notorious, and exclusive, because when I wrote my answers for the bar exam, 1979, I just had to use the letters, the words for continuous, open, notorious, exclusive, and explain that in the back pattern. The possession, and it must be a length of time. I think we said at that time it was 20 years or more over the 40 years. It might have been 20 years. So in other words, it must be for a statutory period of time that you must cone. So it must be in actual possession, continuous, open, notorious, and exclusive for, let's just say, 20 years as an example of number of years, and you must find yourself in the situation that you cannot move on and off the land. All right. So the possession must be exclusively done by the person, and the statutory limit must be met, and this varies from state to state. It can be from 5 years to 25 years. So I think it was 20 years. It was 20 that we had here in Illinois. So that's another way to get it. In other words, here's the theory behind that. If it makes any sense to you, it does. If you allow someone to do something like use your property for that length of time, pretty much what you said is that it's okay, and they obtain adverse possession. Now, there oftentimes it ends up in court if there's a debate about it, because what that person will do during that period of time that they are on that property, make improvements to the property, and so therefore the law allows that individual to be compensated for the time and effort and enriching that property that they have, and that you defaulted or allowed them. That's why it has to be continuous, without break, open and notorious. In other words, so that the owner could see it or others can see it, and then exclusive, and it's that individual, okay? If you transfer it, you lose it and start all over. So that's it. That's how you deal with real property: purchase, inheritance, or adverse possession. Intellectual property. Intellectual property deals with commonly what is referred to as copyrights, patents, trademarks, and there are differences. For example, if a drink formula is created, it will probably end up being patented. If it's a book or a song or artwork, it will probably be copywritten. You see the C with the circle or you'll see copyright and next to it. I have a little thing that I do that is the word lawyers. I gave it to you in the student lounge. I took and copywrote that back in the 80s. I think maybe even before that, but I registered it with the copyright agency, and then I had to renew it. So anyway, we're going to break these down. So if you have a logo and a slogan, that's going to end up being trademarks, okay? All right, then we'll talk about trade secrets and patents. So let's start off by talking about patents. Now, there are usually attorneys that are called patent and trademark attorneys. That's their specialty. That's what they do, and they practice before the federal government dealing with patents and copyright, particularly patents. So, and it's a period of time, roughly 14 to 20 years. So they give some examples: utility and plant patents, which cover newly invented. So if you invent something, you're dealing with a patent. And then they give a number of years and so forth. So it's to protect the work of someone who came up with an idea so that they can make a living. After a certain time, the protection ends and anyone could use it unless they renew it. Now, there's a subdivision that's near where I live now, and there are people who live there. And these people they become inventors. They invented something as simple as years ago the pet rock. That's dating myself, but some of you may know about that, or anything else that you invent. And what you will do is you will take that item, if you want to protect it, and you will register it and pay a patent. And then I don't know all the steps that you go through because I'm not a patent lawyer, but when, for example, let me give you an idea of in my experience. I had a dentist who was a client of mine back in the 80s, and the dentist came to me with this prototype or design for a toothbrush that was a disposable toothbrush, and that he had it made so that the toothbrush, when you opened it up out of the plastic and slid the little bar up, the toothpaste that was in there went on to the brush, and you use that to brush your teeth, and then you throw it away. So it's disposable, very sanitary and everything. Very good idea. So I told him, I said, okay, now, I said, what we need to do is, as your attorney, I will retain a patent attorney to work with me. And then I told him, you know, it was very expensive. I told him how much it would cost to do that, in addition to have me as his representative. So he said, yeah, that's kind of expensive. He said, but what I do have is I got this thing in that someone gave me that tells me of this company that I could submit my my prototype to them, and then they would take care of it for me, patent it, and then I would receive the benefits. I told him, don't do that because of the fact that these are not lawyers. The patent lawyers are lawyers. They are registered. They are held to the responsibility of not, a fiduciary responsibility of not appropriating the item for their own personal gain, but are paid a salary and a fee to go ahead and do what needs to be done. So anyway, this individual decides he's going to take the shortcut way, and he comes to see me maybe about a year later, something like that, but some time passed. And when he came back to me with one of these magazines. You all have seen these magazines where you could get novelty things. Wright was the name of one company that put out these magazines, and in there they had little knickknacks, different things that you could order and buy in quantity, or you could buy them individually. Well, in this magazine, he showed me and he circled. He says, "This is my product." He says, "And they're selling it." I said, "And?" He says, "And I reached out to them, and they said that they weren't they bought this idea, and they named the company, and sure enough, you can figure it out. It was the company that I had told him not to use." And he had signed the rights over to them. When he signed up for them to help him, there was some fine print in there that he didn't pay close attention to, and he ended up becoming the victim of losing his patent. Therefore, his hard work and the wealth that came about was, it ended up gone by the wayside. Okay? So you have to go ahead and follow the steps. And a lot of times when people have products that they put out, they'll say patent pending, but that means they will have filed something with the proper agency or organization. It is not a good idea to use, and we're going to talk about it in conjunction with copyrights, what we call the poor man's copyright, where at one time it was thought that your idea could be put in an envelope and you could send it to yourself, have it postmarked, and that was showing the date and time that you had the idea. Doesn't work. So anyway, patent, that's an idea of how patents work, so you have that. Trade secret is a process that's not made publicly. For example, one who works at McDonald's, one who works at Burger King, one who works at Kentucky Fried Chicken, one who works at any organization, they have a process, and you sign a document not to disclose that process, and it says that it's protection indefinitely, but the key is it must be remained secret, or it becomes fair game for the public to copy. Now, let me give you an example. There is a law called Uniform Trade Secrets Act, which has been adopted in most states, and this provides state protection. So the laws can vary depending on what jurisdiction that you register this product in. But here's my point. My point is this: you can allow it to become public. Let me give you an example. Xerox, okay? Now, the original copy machines that made copies was called Xerox. However, what Xerox did was, and this kind of more applies to trademarks, but anyway, it trade secrets too. The idea of calling it a Xerox copy became the way that we, as we came up, started referring to copiers that were even on different kinds of machines. But we used the term Xerox, and Xerox allowed that name to become, as we say, generic. There's some other things I can't think off the top of my head, but the point of the matter is that you allowed it to become common and use. I can tell you that working at for a law firm I worked for many years, starting in the mailroom, you heard me talk about that, all the way up to becoming a lawyer, a firm called Sonnenschein. We had McDonald's as a client, and we dealt with a lot of issues. Like, for example, a lot of people laugh about the secret sauce that's put on the what is it, the burger called? I can't think of the name of it, but you know, the Big Mac. Thank you, the Big Mac. And so, as a result, then that was protected, that sauce. Even the tartar sauce was supposed to be their own specialty. And you hear a lot of companies, organizations say we have a secret recipe. Kentucky Fried Chicken had one, and all the different companies had their own little secret recipes. And so anyway, the bottom line is that if a person violates that, they can be sued for it because it's to protect the efforts of the person who created it. Now let's move right down to trademarks. See, when we get to trademarks, trademarks protect, identify, puts a name on the product. And they can range from books to sound, video recordings, to computer software. So they have what they call the digital millennium. I'm sorry, I jumped down into copyrights. Trademarks is how a product is marked. The label, the guide is on how the item is marked. So trademark can last indefinitely as long as they are continuously used in commerce, but you also renew them. The federal government has trademark protection under the Lanham Act, but most states have their version of it. For example, like McDonald's, for example, we had some people tried to use McDonald's name and spell it like you saw Coming to America. If you saw Coming to America, you remember in there was a restaurant called McDougal's, and they were utilizing the Big Mick instead of the Big Mac. And they had, if you looked at their menu, it had close names to it. Well, if the public could confuse them or associate them, then it was a violation of the trademark. And so the key thing is that your company, even like, for example, Allstate, if you looked at Allstate, you'll see next to it a little R for registered, protecting their name. You'll see a lot of commercials and things of that nature, and they have the name protected. So, but it's also recorded. Let me give you another example. Down in Illinois, Southern Illinois, where one of my daughters attended Eastern Illinois University, which, by the way, just for your info, is the home of Jimmy John's, and that's where it originated. But there was a restaurant that was just across the highway, and it was called The Burger King. That was the name of it, The Burger King. Well, Burger King took them to court and forced them to change their name because they were a conglomerate and they had the trademark, and it could confuse people about them. And just because it was it still didn't matter. It was still close to it and close enough to create confusion to the public. So under the trademark laws, they were protected. But we had many trademark infringement lawsuits that we had when I was working at the law firm where our #1 client, McDonald's, was under attack by other organizations. Did you not know that the color that McDonald's uses, that golden yellow, is actually their created golden yellow color, and they have a trademark. It belongs to them. So they use it, they allow it to be used on T-shirts, on caps, on billboard signs, all other kind of things. But here's my whole point in a nutshell, is that no one else can use that color because they own it, unless they pay them a fee for it. So that's what trademarks are, to protect how the product is labeled or marked so that you know who the owner of that is. Finally, there's copyrights. Now, copyrights started out with written documents, but then it changed, as I said earlier, from books to recordings, to video recordings, to computer software, and then there is the Digital Copyright Act to protect copyright infringement. And when the internet came about, it created a vast amount of instances. You know about bootleg music, bootleg video, and it also talks about the fact that when you provide information that you utilize in a song, in a written material, or something of that nature, they have what they call fair use laws, which allow you to use a small portion of it. But if you go beyond that, and there have been lawsuits that were filed, Michael Jackson, Bruno Mars, and just to name a few, where there's allegations that they stole their song from someone else. I listen to songs sometimes, and I say, hey, that song, I know that song. That relates to some song that I heard earlier. Well, either they have the written permission of that individual to use that song. In addition, if someone does a remake of a song, a video, movie, or something of that nature, they also will probably compensate the individual who originally copywrote that. And so usually copywritten is indicated by the name of the organization with a little small c with a circle next to it in there. And then, or you might see the word copyright, and then it'll say the year. And then it's renewed. So intellectual property basically covers these areas, and what companies will do is issue what we call licenses. As I said, that's how they get permission to utilize those songs, those pieces of art, and other information. Not too many companies allow their trademark to be used, especially if it's going to create a legal problem for them. So, so the key is, summing it up as it says at the bottom, is the intellectual property laws protect the ideas and allows you to continue to make money. So you can create something and live off of it. So, and then these are some sources that were used to get the information that I just covered. So that should explain the issues dealing with property, intellectual property, and so forth. And then again, the eminent domain. So what is eminent domain? Eminent domain, very simply stated, is when the and it's in your book when you read the chapter, is when the government takes the property for public use, or put it to what we call a better use, which means that if a person has some property, let's say, for example, to give you an example, they were building a highway. There were people whose houses were sitting or owned the land where they wanted the highway to go through, and it was the most efficient way. They had to get those people to sell their property. If for the public good that the person was stubborn, then what the person who has the project might do is take them to court and utilize the law of eminent domain to seize control of that property or ownership of that property. However, they have to compensate that person for what we call the FMV, the fair market value of the property. And there are other rules that are involved, but that's the simplest form. And so that's what eminent domain is. It also involves private entities want to expand. However, they have a very, very serious burden that they must prove. So here is eminent domain, and if you want to know what that, you flip the card over. Taking of land with just compensation and historically used for utilities, but also, as I said, it can be used for highways and things of that nature, okay? So then you go to the next one, lost property, and you click on that. It's abandoned. You heard this one, finders keepers, losers weepers. Finder must, lost, finder must return to the owner. Mislaid, finder must care for the property. So if someone finds some property, my wife recently at a restaurant in the ladies' room found a ring, and she turned it over to the restaurant people, and we don't know what they did with it. However, if someone didn't claim it within a period of time, she can go back and she could become the owner. But that's what we mean by loss or mislaid. A bailment comes about, has nothing to do with jail, giving a personal property to another with the agreement to return it. A common bailment is car rental or property, or either, let's say, for example, you go to a place like Rent-A-Center or one of those. A bailment is created. However, though, there's an option in there usually that allows you to buy it. But the bailment basically is you, in turn, agree to return it within a period of time, or whatever the period of time that you've agreed. Sole benefit of the giver, sole benefit of the receiver, mutual benefit. Fee simple. This is language that you'll find pretty much in real estate deals, which means you're the full owner, so you own all of it. Life estate pretty much describes it. This is a property issue, means you own and use the possession for your life. Easement or grant a license. I'll give you an example of that. Usually, for example, if you have a piece of property and your property, the person passes through your property to get to their property, and that's the only way they can get to it, easement could be granted to that individual for the sole purpose of entrance, or we call it egress and entrance, allows the person to travel over the land. Okay. So, and you know, joint ownership means what it says. Community property, that usually is out west. Half ownership, tenancy in common, which means that the property passes to the heirs. Joint tenancy usually means that when the one tenant dies, that the survivor becomes the sole owner. Okay. Then we already talked about intellectual property. We talked about copyrights. Example of copyrights. I told you these are some examples. Trademarks, we talked about that. Elements of a legal trademark. Distinctive, so that when people see it, like for example, when you see the golden arches, what do you think of? McDonald's. Okay. Trade secrets. Protected under common law, but must be info not generally known and have some value commercially. Okay. Property. Anything that's owned, tangible or intangible. Personal property. We already covered that. Real property. Eminent domain. Again, taking of land with just compensation, historically taken for the use of utilities and so forth. And that's it right there. Now, some common ownerships of property, we've already kind of talked about that. You learned about real property, but you know, it's not something that you really have to be that much concerned about. But I already told you what fee simple means. You're the sole owner. I'm not going to get into fee simple, defeasible, but there are restrictions on use of the land. For example, you donate your land to the city as long as used for a playground, so you put a restriction on it. If at any time it ceases to be a playground, then it comes back to you. Life estate for the life of that person. I already explained tenant in common, joint tenancy. Tenant by the entirety is a specially recognized thing that happens between husband and wife only. Only husband and wife. Now, with the laws changing with civil partners involved, where people don't get married and I'm not just talking about LGBT, but I'm talking about anybody, then I don't think tenants by the entirety still applies to them. I think it only applies to husband and wife. Okay, and that's it for today. And I want to give you a phrase, and we'll go back to class. And that phrase is eminent domain. That's it. So you give me that to get your point. Hope to see you next week for the final lecture of this course. And we'll see you then. So have a good evening. Good night.